Hello and welcome to this webinar on how to determine a flexible tenancy during its fixed term. I'm Ricardo Calzavara, a barrister at Cornerstone Barristers. I've seen the list, so I know many of you already. Hello to you in particular, but to all of you. And I'm giving this talk because I recently appeared for the authority in the case that finally decided the question that I'm considering this morning, which is how to determine a flexible tenancy during its fixed term. You will all have seen it. It's Croydon and Kalonga, and it won't be a spoiler to tell you that we lost that case. This webinar will be about the effect that the decision will have on all local authorities that use the flexible tenancy regime. On the last count, there were 151 of you signed up for this, including Jenny Fraser-Brown, who instructed me on the case. Some of you have posed some questions in advance. I'm going to try and address them during the course of the webinar, but do feel free to nudge me if you think I haven't done so. Most of them I'll respond to, as I say, during the course of my talk. Some of them I've left to be dealt with at the end. And if you want to ask any other questions, there's a Q&A box at the bottom of the Zoom page. If you fill that in, I'll get to it at the end. I expect to be presenting for somewhere between 20 minutes and 30 minutes. And I understand that Carolina, who's kindly hosting this, is recording what's being said, so it will be available for viewing afterwards in the event that you wanted to catch up on something. A quick factual background: Ms. Kalonga was granted a 5-year flexible tenancy in May 2015. There were various allegations of antisocial behaviour being perpetrated at the property, not necessarily by her, and there were substantial rent arrears at the time the claim was brought. As it happens, by the time it was decided, there were none. A notice seeking possession was served, relying on those breaches of the tenancy and grounds 1 and 2, and a possession claim was brought in the county court in August 2017, which is a long time ago now. Ms. Kalonga wasn't represented at that time, and in April 2018, after at least 3 hearings, a possession order was made. That was when solicitors came on the record, and I understand that we have 1 or 2 people from GT Stewart's who are the solicitors who acted for Ms. Kalonga here, so welcome to you too. An appeal was brought against that possession order on 7 grounds. That appeal was allowed, the possession order was set aside, and the matter was relisted for determination from scratch. This time, Ms. Kalonga put in a defence, not having done so on the first occasion. And the main tenet of that defence, at least for the purposes of this decision, was that Croydon wasn't able to recover possession of the property because the tenancy agreement didn't contain a forfeiture clause. So this defence, put in on behalf of Ms. Kalonga, is the basis on which we have the argument that gives rise to the interesting point that comes from the judgment of the High Court and that we'll be discussing this morning. There was also a number of other defences based on alleged disability discrimination and breaches of the public sector equality duty, and those defences will come up for determination in the event that an appeal is allowed and we go back to the county court to decide whether a possession order should be made. There was also a disrepair counterclaim, but that's to one side for now as well. In its reply, Croydon asserted that it didn't rely upon forfeiture. Because of that disjunct between what Ms. Kalonga said the position was and what Croydon said the position was, Ms. Kalonga applied to the circuit judge for the matter to be transferred to the Queen's Bench Division because of the general public importance of the matter that had to be litigated. The application was dismissed on the papers, but His Honour Judge Bailey allowed it at an oral hearing in May 2019. And we, to bring the factual background to a close, finally got before Mrs. Justice Tipples on the 8th of April 2020, which is almost 3 years after having brought the claim. I've said that the reason the matter was transferred to the High Court was that it was of general public importance, and what was of general public importance was the question how to determine a fixed term tenancy during its fixed term. That's not a new problem. Since inception of the secure tenancy regime by the Housing Act 1980, local authorities have been able to grant fixed term tenancies. It's difficult to find that section now because Westlaw shows it as not in force, and the legislation.gov website crashes whenever I try to find the as enacted version of the 1980 Act. But for anyone who wants to look it up, the old version of what we see today in section 82 is section 32 of the Housing Act 1980. That ability, the ability to create fixed term tenancies, continued when the Housing Act 1985 was enacted and still continues today. But how do we know that a secure tenancy can be granted for a term certain? Well, that is in section 82 of the Housing Act 1985. I hope you can all see that as my second screen. And this is section 82 of the Housing Act 1985. A secure tenancy, which is either a weekly or other periodic tenancy, that's the normal type of tenancy that we as local authorities grant, or a tenancy for a term certain. So we know from section 82 and from various other provisions that a term certain is a type of tenancy that can be granted by a local authority. In practice, very few local authorities granted fixed term tenancies until the Localism Act 2011 introduced sections 107A to 107E into the Housing Act 1985. The relevant part for our purposes is section 107A, which I hope you can all see. And that provides what a flexible tenancy is. And the briefest way in which it can be put is that a flexible tenancy is a secure tenancy granted for a fixed term of at least 2 years. The main way, at least for our purposes today, in which it differs from another kind of, or any other kind of fixed term tenancy, is that it has its own regime for mandatory determination at the end of the term. And those are the provisions in section 107D of the Act that we don't need to look at. Because of section 86, any other fixed term tenancy that isn't a periodic tenancy automatically becomes a statutory periodic, that isn't a flexible tenancy. I'll do that sentence again. Because of section 86, any other fixed term tenancy that isn't a flexible tenancy automatically becomes a statutory periodic tenancy at the end of the term. This is section 86, where a secure tenancy is a tenancy for a term certain and comes to an end by a fluxion of time. A periodic tenancy of the same dwelling house arises by virtue of this section. So the big difference there is that once you have come to the end of a flexible tenancy by a fluxion of time, of a fixed term tenancy by a fluxion of time, you get a statutory periodic tenancy. And that means that you can only determine that tenancy on the usual grounds in section 84, most of which are reasonableness grounds. At the end of a flexible tenancy, which is different, you have the opportunity as the local authority to seek possession on the mandatory basis set out in section 107D. And whereas under section 84, sorry, this is very technical, lots of sections to refer to. Whereas under section 84, you have to satisfy the court that the ground is made out and that it's reasonable to make a possession order. In the flexible tenancy regime, at the end of the fixed term, you have to satisfy the court primarily that you've properly carried out the review procedure. And that's what the conditions in section 107D relate to. Now, of course, if the flexible tenancy isn't brought to an end in the way envisaged by section 107D at the end of the term, it becomes a periodic tenancy in the normal way. So there's only a brief opportunity for a local authority to determine that tenancy at the end of its term on a mandatory basis. And this isn't the time to go into it. You can see it on the screen if the screen sharing is working, but you'll all be aware of the provisions relating to the service of a 2-month and 6-month notice preceding the bringing of a possession claim on the coming to an end of a flexible tenancy. As it happens for the duration of the Coronavirus Act 2020, the 2-month notice is a 3-month notice. So anyone intending to serve those sorts of notices in the next couple of months should look out for that. None of that, though, helps us with how to determine a flexible tenancy during its fixed term. This has been the subject of much debate, particularly over the years since the Localism Act 2011. But that isn't because the problem of determination is new. It's applied equally since 1980. It's because for the first time, after the Localism Act 2011 was brought into force, local authorities were actually using fixed-term tenancies. And there were 2 arguments, one proffered by John Holbrook of Cornerstone Barristers, and the other by Andrew Diamond of 4 to 5 Gray's Inn Square. And for anyone who wants to see them, Andrew's are in the Journal of Housing Law in 2014, and John's are in the New Law Journal in 2012. John's argument was that a flexible tenancy is determined in the normal way by section 82, and we're going to come to section 82 in a moment. He said the only real difference was that a different notice of seeking possession had to be served. Now, someone has asked the question about this in advance. I'll answer it now. The type of notice that you have to serve is the one prescribed by Part 2 of the Secure Tenancies Notices Regulations 1987-755, rather than Part 1 of those regulations. Andrew's argument was that for various archaic reasons, determination pursuant to a possession order in the normal way, so in the section 82 way, would only serve to determine the periodic tenancy, and that any fixed term tenancy would still exist unless it too was severed by forfeiture. The effect of Andrew's argument was that you couldn't actually evict a flexible tenant with a normal possession order because the fixed term tenancy continued, surviving the possession order. Now, I've abbreviated that argument so that it probably bears no relation anymore to what Andrew said, but for the purposes of this talk and for the purposes of the argument that we had before Mrs. Justice Tipples, that was the dispute between the 2 camps. A similar argument to the argument posited by Andrew that you need forfeiture was run in the assured tenancy context in a case called Artesian and Beck, for anyone who's interested to look into it further. The forfeiture only assertion that Andrew advanced was pretty bold. Forfeiture is, at its root, a landlord's right to physically re-enter into property. It makes very little sense in the modern context, particularly when the Protection from Eviction Act 1977 explicitly rules out recovery of possession of residential property by re-entry. Well, it makes it a criminal offence. We have Section 2 of the Protection from Eviction Act here. It shall not be lawful to enforce that right otherwise than by proceedings in the court while any person is lawfully residing in the premises or any part of them. So concerned with this issue were those that agreed with Andrew's line rather than John's line, that in section 119 of the Housing and Planning Act 2016, Parliament legislated to make it clear that forfeiture was not necessary for any fixed term tenancy entered into after the relevant section came into force. Section 119 looks like this, but it's much easier to read it by looking at section 82 as it would be in the event that section 119 is ever brought into force. Now that amended version of section 82 is all well and good, except that section 119 of the 2016 Act has never been brought into force, and the present government's made it clear that it isn't going to commence it. Even if it did bring it into force, the old provision would still apply to pre-commencement tenancies. That's because of the difference in the drafting between section 82A1 and section 82A2. So the old problem, the Kalonga problem, would still exist. Someone asked in those questions that I've referred to before this webinar, what the implications of this decision are in light of the Housing and Planning Act 2016. I've understood that to mean in light of section 119. And the answer is that until section 119 comes into force, the relevant part of the Housing and Planning Act and the amendments that it makes to section 82 of the Housing Act 85 are irrelevant. Even when it comes into force, it will only apply to tenancies granted after commencement of the amended version of section 82. This trial was effectively the hearing, finally, of the arguments that John and Andrew had been making in their various articles. So it was the hearing of a question that had existed for 40 years. It hinged on three main arguments. The first was, what does subject to termination mean in section 82(1)(b)? The second was, is it only permissible to recover possession during the fixed term of a flexible tenancy by the forfeiture-like procedure in section 82(3)? And the third was, does the instant tenancy agreement contain a forfeiture clause? I'm going to explain those three arguments now, three questions now. The answer to the first is of general application, as indeed is the answer to the second. The answer to the third is of more limited application, but it will help other authorities to work out whether their own form of wording suffices. I'm going to look at those three arguments in turn. We have to start with section 82(1)(b). Section 82 provides that a secure tenancy, which is a tenancy for a term certain, but subject to termination by the landlord, cannot be brought to an end except as mentioned in subsection 1A. The reason the words subject to termination are important is that you don't get into section 82(1)(a) without being a fixed term tenancy subject to termination by the landlord. And we see that because of cannot be brought to an end except as mentioned in subsection 1A. We argued that those words, subject to termination by the landlord, meant by any lawful means available. So we invited Mrs. Justice Tipples to read it as subject to termination, a tenancy for a term certain, but subject to termination by any lawful means available. That would include forfeiture, a break clause, and any other contractual provision that allowed the authority to recover possession of the property before the end of the fixed term. The barristers for the other side, Justin Bates at Landmark Chambers and Annalie Robbins at 45 Gray's Inn Square, argued that the words subject to termination by the landlord were restricted to by forfeiture alone. So they invited Mrs. Justice Tipples to read section 82(1)(b) as a tenancy for a term certain, but subject to termination by the landlord by forfeiture alone. We supported our argument by reference to section 82.3, which provides for a provision for re-entry or forfeiture. And we invited the judge on that basis to find that Parliament had been able to distinguish between termination per se in section 82.1b and a provision for re-entry or forfeiture in section 82.3. And we invited her to find on that basis that it could not be read. Section 82.1b could not be read with the narrower meaning that Ms. Kalonga posited. The judge disagreed. This is her judgment again, I hope you can all see it. At paragraph 12, she held that in the event of default by the tenant, the landlord cannot determine the flexible tenancy prior to the expiry of the fixed term unless the flexible tenancy contains a forfeiture clause which enables the landlord to determine the tenancy at an earlier date. The effect of that is that she found that Ms. Kalonga was right, that subject to termination means by forfeiture alone. I don't need to take you to it now, but the argument is bolstered, or that the conclusion that Mrs. Justice Tipples gives is bolstered in paragraph 49. But that's not quite a complete picture, because she also thought, but didn't decide, at paragraph 11, that a break clause might suffice. That's this passage here. That route, that break clause route, might be an interesting avenue for those of you who don't have a forfeiture clause, but do have a break clause. Although no doubt, given the decision in Kalonga, you'll no doubt have to litigate the point on appeal to see what the answer is to the question that Mrs. Justice Tipples hasn't really even pronounced on obiter. The consequences of the judge's decision are that if you have a flexible tenancy, you need a forfeiture clause or possibly a break clause to even get past the first part of section 82. So to get from a tenancy for a term certain to, as mentioned in subsection 1a, bringing a claim for possession, you need to have a forfeiture clause. And that means, in answer to the very many questions on this point that were put to me in advance, that if you ever want to recover possession of a flexible tenancy or any other fixed term tenancy during its fixed term, you have to have drafted a forfeiture clause or a break clause, possibly, into your tenancy agreement. That has enormous consequences. In addition to stopping a possession claim being brought on any of the reasonable grounds in section 84, which we've already looked at, the judgment has the effect of preventing an authority from bringing a possession claim under section 84A, where, for example, there's been serious criminal conduct committed at or near the property. We argued that, we mentioned that in the appeal, excuse me, in the hearing, but the judge wasn't convinced that that should give rise to an alternative effect. That's because you don't get into section 84A without having gone via section 82(1) capital A. And it also means you can't demote under section 82. Again, because you only get into section 82A via section 82(1) capital A. Some of the questions I was asked in advance related to what the landlord can do in these circumstances. And the answer, I'm afraid, is that the landlord has to rely on its ability to seek an injunction to enforce the terms of the tenancy. But because section 84A, the mandatory ground where there's been normally serious antisocial behaviour, follows from section 82(1) capital A, and because that landlord would be without a forfeiture clause, you can't even rely on breaches of that injunction to found the mandatory right for possession contained in condition 2 of section 84A. This is the crux of the decision in Kalonga. It's the reason the decision matters, and it's a really big deal. Forfeiture itself is useless in the social housing context, but now forfeiture clauses are not useless. A forfeiture clause normally says that in the event the tenant is in breach, the landlord may re-enter on the property and thereby recover possession of it. As I've said, and as you all know, in the residential context, that would be unlawful and a criminal offence. But the effect of this decision is that local authorities have to draft into their tenancy agreement a forfeiture clause, which is not binding on the parties, in order that it can bring a claim for possession in the normal Section 84 way. That will be the main focus of the appeal to the Court of Appeal. That's the first argument. The second and third are much shorter. The second argument was about whether it was only possible to recover possession during the fixed term by the forfeiture-like proceedings in Section 82. In Section 82.3. This is Section 82.3, and what it provides is that if you want to bring a claim of that sort, and just look above to Section 82.1, capital A, B, that leads you to subsection 3, and then these are the words of subsection 3. What it provides is that if you want to bring that sort of possession claim, the court will determine it as if it were forfeiture, but not using forfeiture. This was the argument that led to the matter being transferred to the High Court. Ms. Kalonga didn't argue just that you needed a forfeiture clause. She also argued that you needed to use it because of Section 82.3. We argued that there was no principled basis on which that might be the case. Our argument was that Section 82.1a, which you can still all see, gave a menu of options. It made it clear that the tenancy would come to an end. This is may be brought to an end in the event that one of these three things occurred. We argued it didn't provide that in any particular case, a landlord had to elect any one of those three things. And on that argument, we won, fortunately. The relevant part is paragraph 61 of the judgment. The judge held that she did not agree with Mr. Bates that even if a flexible tenancy contains a forfeiture clause, the only way a landlord can bring it to an end before the expiry of the fixed term is ... forfeiture. This is because if a flexible tenancy contains the forfeiture clause, the landlord can bring the flexible tenancy to an end if the tenant is in breach by any of the routes identified in Section 82.1a, depending on which route is most appropriate in any particular case. What that means is that as long as you have a forfeiture clause, you can bring a normal claim for possession. That's a rather strange result, and it's not one that either of the parties advanced. I was arguing, one, you don't need a forfeiture clause, and two, you don't need to bring a forfeiture-like claim. Ms. Kalonga was arguing, or Mr. Bates on her behalf, you do need a forfeiture clause, and you do need to bring a forfeiture-like claim. The judge found for Ms. Kalonga on the first, and for Croydon on the second. You need a forfeiture clause, you don't have to use your forfeiture clause. And the third argument was about whether Croydon had a forfeiture clause. There were 4 clauses that we relied upon in the tenancy agreement. They're listed at paragraph 19 of the judgment. We argued that those amounted to a forfeiture clause in the Clay's Lane sense, and for anyone who wants to see that reference to test their own clauses against, at paragraph 20, Mrs. Justice Tipples cites the important passage. And she then held at 23 that I was wrong that the conditions in Croydon's tenancy agreement didn't amount to a right to forfeit the tenancy agreement. The effect for Croydon, if we can't upset this decision on appeal, is that we can't determine any of our flexible tenancies during their fixed term. That effect will be the same for other landlords who don't have a forfeiture clause or who have clauses that look like Croydon's. But those landlords who do have a forfeiture clause, or as I've said twice, possibly a break clause, will now know that they will be able to determine their fixed term tenancies in the normal way. So the second proposition, the one that you can determine a tenancy in the normal way, is a good result for landlords across the board. The first proposition, that if you don't have a forfeiture clause, you can't determine the flexible tenancy during its fixed term, is a bad result for landlords across the board. Based on the questions that I've seen, many of you will be pleased to hear that we're seeking permission to appeal. The trial judge refused permissions on the papers, so we're renewing to the Court of Appeal. We haven't lodged our grounds yet, so I'm not going to go into too much detail, but suffice it to say that we'll be challenging the assertion, or the assertions, that you need a forfeiture clause, and if we're wrong about that, we'll be challenging the assertion that we don't have one. And the answer that we're advocating for is that as long as there is some contractual entitlement to determine the tenancy during its fixed term, that is sufficient to entitle the landlord to recover possession in the usual way. Now, that is what I wanted to say. I'm going to look at the questions now. Give me a moment to collect myself. Someone's asked the tenant a question about 5-year fixed term tenancies as well. Where the question is, I work for a housing association, so presume this applies to our 5-year fixed term tenancies also, i.e. cannot be terminated unless it has a break clause or a forfeiture clause. The answer to that is that it's not quite as simple, because the regime in the Housing Act 1988 is different. The most important decision to look at on that is Bamber, which you'll be able to find on Westlaw. And without looking at the Act, I can't answer the questions substantively, but I will make a note that you've asked it and get in touch afterwards to see if I can better answer it. Another question, what if the tenant has parted with possession, i.e. sublet, and is no longer living there? Can an NTQ not be served? Well, that was also a question that I got in advance, so I've had to think about that. It's a really interesting question, and the answer is not at all obvious. What normally happens when a tenant ceases to occupy the property as their only or principal home is that they lose security of tenure. That's because of sections 79 and 80. That entitles the landlord to serve a notice to quit to determine the contractual tenancy, which is all that remains because the secure tenancy has disappeared. Security is ambulatory unless there's subletting. So the land, in which case security extinguishes. So in a only or principal home case, the landlord must establish that the property wasn't being occupied as the tenant's only or principal home at the time of service of the notice to quit and at the time of expiry of the notice to quit. That's normal, everyone, I'm sure, is with me. The problem in a fixed term tenancy case is that a notice to quit is only effective in relation to periodic tenancies. So if that were not the case, the issue in these proceedings wouldn't have arisen, because you don't need a clause to say that a notice to quit can be served in relation to a periodic tenancy. You might have clauses that say the period that the notice to quit might have to be served in relation to, but you don't need a right to serve a notice to quit. That is inherent in a periodic tenancy. So what does happen in a fixed term tenancy case? Well, section 107D doesn't help, because that only applies at the end of the fixed term. And section 82 doesn't help because that only applies to secure tenancies. And this tenancy is no longer a secure tenancy because the tenant has abandoned the property or sublet it. You can't determine it under section 82 because you're not a secure tenancy anymore, and you don't have a forfeiture clause, so you can't determine the fixed term tenancy in some other way. The problem is that unless and until, and it looks like this isn't going to happen, the relevant parts of the Housing and Planning Act 2016 are enacted, you as the landlord are stuck with a tenant not living in the property and not having an appropriate means to recover possession of that property. Got another question here. Isn't it correct that you cannot amend the tenancy agreement during the fixed term due to section 101? Well, that was another point that we made in argument, that during the fixed term of the tenancy, you can't add, you can't change, you can't vary clauses without the tenant's consent, insofar as those clauses don't relate to rent. So yes, you can't unilaterally add a forfeiture clause to a tenancy agreement. You have to have the tenant's consent to add it. And well, the expression that's often used is that turkeys don't vote for Christmas. You're very unlikely to get a tenant to agree to stick a forfeiture clause into a tenancy agreement that doesn't already have it. I've got another question here. What would a suitable forfeiture clause look like that would pass muster? Thank you for that question. That's the million-dollar question. I looked into this yesterday, as it happens. There is a form of forfeiture clause that's recommended. I'll find that in a moment. I'll tell you the answer to that in a moment. The difficulty is that the forfeiture clause looks very strange in an agreement that actually can't be determined by forfeiture. A couple of other questions. I'll see if I can answer 3 more. Has forfeiture ever been used by local authorities seeking possession of a fixed term tenancy? Not that I'm aware of, but it's possible that it's just never made its way to the higher courts. What do I do if I don't want to grant flexible tenancies in the future? Well, the answer is go back to granting periodic tenancies that can be determined in the usual way, or grant flexible tenancies that contain a forfeiture clause, or argue that your tenancy agreement does contain a forfeiture clause because it's different to the Kalonga clause, or wait for the Court of Appeal and possibly the Supreme Court to rule on this question. Another question, can a fixed term tenancy be determined and a periodic tenancy re-granted? Yes, with consent, or if the tenancy contains a forfeiture clause in the event of the tenant's breach, or by waiting until the end of the tenancy agreement, and that is what happens automatically. Now, I promised a better answer to an earlier question about the determination, about the wording of a forfeiture clause. The best place to look, the best one I found, is in the Law Society's short form model lease. And that contains words that you might want to use in the drafting of a forfeiture clause. It seems like you can see each other's questions. I hadn't realised that. Victoria, thank you for your answer to Fabian's question. And Aisha, I've said that I'll answer yours afterwards if I can. If anyone writes something in the next few seconds, I'll answer it, and otherwise I will bring this webinar to a close. Great. Well, thank you all very much for joining. I hope that your questions were answered and that this was informative. And as I say, watch this space. We'll see what happens. See what happens at the next stage if the Court of Appeal is interested in hearing our arguments. Good morning.